Mr. Hart.
Gave a rather over hasty assent to my Lord Justice Nugee's question about what we want is more sewers. That's the nub of it. As I indicated right at the beginning of my submissions, actually, that's not what this case is about. This case is in effect a commercial dispute between the Canal and United Utilities, wishing United Utilities to pay rent for the benefit of having the sewer put into the canal. Of course, again,
so you're content for it all to go on as long as you get paid for it?
Yes. I also indicated at the beginning that there were wider questions involving environmental interests, and hence the point about the interveners. I hope that clarifies my position.
Thank you.
What I was now going to turn to was trying to work out what the provisos might mean if I'm wrong. And so for that purpose, one needs to have a look at two passages of what the judge says about that.
Can I, just before you go on to that, pick you up on what you've just said? If you're successful in this appeal, there will then be a commercial negotiation.
Yes.
As to the rent to be paid.
Yes.
For the right to continue polluting the canal.
Yeah.
There's no statutory mechanism for fixing that rent at a reasonable level. It's just a purely commercial negotiation.
That's right.
That means that the rent you will be able to demand will be affected by what the alternatives are for the respondent. And if the only alternative, if they can't use your canal, is they have to go and get some rights from somewhere else, or build more capacity, you are in effect saying, well, either pay us what we want or build more sewers or find somebody else who can give you rights.
Well, who knows how the commercial negotiations might go, given the different permutations which may arise and the different potential ways of you mitigating things or coming to a commercial settlement with us as to the effect on us of the discharges.
Yes, I see. Thank you.
I said I was going to move on to the provisos and have a look at two passages from the judge's judgment where he says, it gives possibilities as to their role. The first passage, I don't know whether you have the judgment loose, but it's page 194 of the bundle. And it's paragraph 76 of the judgment, where the judge says this. First, proviso upon which MSE principally relies, do not confer or preserve a distinct right of action for a person affected by unlawful discharge of foul water into watercourse. Agreed. They provide that the exercise by an undertaker of any of the powers does not itself confer upon the undertaker an immunity from private law action. That is to say, the specified powers do not have to be construed as providing that an undertaker may, without fault, commit a nuisance. And then this conclusion. The purposes of the subsection is accordingly to remove any argument based upon their principle in Allen and Gulf Oil that an undertaker has a defence of statutory authority. There are, to that extent, provisions that can be said in broad terms to preserve rights of those riparian owners intended to be protected, but they're not an answer to the question whether as a matter of construction a private law claim can be maintained on the facts of individual cases, any more than the preservation of other remedies by 18.8 gave Mr. Marchich a valid claim in negligence. So, I'm sorry, nuisance. The I simply observe this, that one cannot imagine there being any point in removing an argument based upon Allen and Gulf oil without there at least being a contemplation of a civil claim to which a statutory authority defence might be put up. And in a sense that's reflected in what the judge carries on to say when, in broad terms, to preserve the rights of those riparian owners. So what we say is that the reasoning, if anything, in this paragraph does rather suggest that the provisos are something to do with civil proceedings. Though, of course, I readily accept what the judge says at the end, but it's another. The judge's reasoning leading up to that point does rather point in the direction of it being something to do with civil claims, as distinct from UU's position, which is there are no civil claims at all, other than those dependent upon negligence and deliberate conduct, in which circumstances, of course, the Allen Gulf Oil defence doesn't operate anyway. So that's the first passage. The second passage is at paragraph 89, 197 of the bundle. Finally, UU's interpretation of the 1901 Act might be said to be vulnerable to the argument that statutory provisos are ineffective if claims in nuisance or trespasses are ousted on a true construction of the Act. Clearly, the statutory provisos were intended to have some effect beyond signalling that an undertaker would have no defence of implied authority to a claim that an owner had no entitlement to bring. A defence of implied authority would only avail an undertaker that had taken reasonable care to exercise his powers so as not to cause harm in question, not an undertaker that had acted negligently, so pausing there, but fitting in with the Allen Gulf Oil discussion in the previous paragraph that we looked at. It's the next bit we have difficulty with. However, as indicated in Dobson, there might be cases of non-negligent failures where a defence of implied authority could avail an undertaker and where the claim in nuisance might not be excluded as conflicting with the statutory machinery for enforcement of its Section 94 duty. There is, leading to the conclusion, there is therefore scope for the statutory provisos to have some effect. One purpose is to make clear to an undertaker is not permitted to pollute watercourses. We have some difficulty with this because Dobson, you will recall, was the sewage works odour and mosquitoes case, where all the claims were put in negligence. There were in fact no claims put in strict liability, for the simple reason that Allen and Gulf Oil governed the position. Therefore, the claims accepted that they would have to establish that Thames were negligent in it. So we as I say, we have difficulty in seeing that anything in Dobson indicated that there was this category of case. In any In any event, our more general point is that it is, with respect, an extraordinarily abstruse way of giving some sense into the provisos, and a good deal less plausible, we say, than our much simpler approach, which is to say preserve civil remedies. So the judge then really completes his discussion at 90. Although 117 and 1863 is therefore reduced as compared with the equivalent provisions in the 1875 and 1936 Act, they are not ineffective under Nughee's interpretation. So he's acknowledging that the provisos I was going to say have more muscle, I hope that's not unfair, had more to them before, under the 36 Act and the 1875 Act. But that raises the question, in a sense, my submissions this morning, where is there in the consolidating statute anything which suggests that as a matter of construction, the provisos have been shrunk? They're effectively the same old provisos. And with the exception of the more complex enforcement procedure that I took the court through, the Act has effectively the same structure, and therefore we would suggest that it would be extremely surprising if the provisos shrunk without there being any indication in the relevant parts of the 1991 Act that was intention of Parliament. So we say that's highly significant, because if the provisos don't really have a job to do on this construction, it suggests that the construction is wrong, and the simpler and more straightforward one which we advanced is the right one. I shall let Mr. Karras develop in due course his additional ways of trying to give the proviso sense, and respond in due course to that when I've heard him make submissions. But he makes some suggestions as things the judge might have said, and I'll let him develop that and respond. I think that probably brings us on to the linked grounds 4 and 5, which are about uncontrolled escape, about the system being an involuntary one, if I put it very simply. And I mean, which was in effect the judge's conclusion. Our submission is that is simply does not reflect the extent of UU's system, which involves a whole series of different forms of overflows or outfalls, with their own protections, with their own consents and the like, and to say it's inevitable or involuntary because the rain comes down and comes through the system simply does not reflect the reality of this. We therefore say that two things really are arising from that. The first is that it is truly a trespass, and the second is that you is capable of doing things to affect the way in which the system works. And just reminding the court, we're dealing with a series of different structures. We're dealing with the emergency overflows, usually from pumping stations. We're dealing with the combined sewer overflows, which is combined sewer being obviously being foul water from businesses and homes mixed with surface water runoff. We're dealing with storm tank overflows, so that's the storm tank which forms part of the sewage works and takes extra flows and deals with it and hopes to mitigate the amount of pollutant in it when it can and before it is discharged. But in some instance, some works may be overloaded, and so it go through with very limited residence time during the storm tanks. And then last but not least, outfalls from the main treatment works. So this is where the flows have been treated to some extent, to a greater or lesser extent, and there is a complex form of environmental consents on what can or cannot be let out. So to characterise all of that as in some way an involuntary response, we can say is not a correct characterisation.
Can I just ask a question about that? To what extent is it open to you, or can you realistically go behind the judge's findings of fact on the basis of uncontested evidence?
Well, it's the answer is the finding of involuntary is an inference which the judge drew from the evidence, particularly Mr. Hazlitt, thank you, where he set out all the details of that, and what I'm submitting to this court is that on a proper understanding of his own evidence, it would be perfectly appropriate for the court to conclude that that it wasn't involuntary in the sense that the judge is referring to.
And so are you saying that we need to look at that evidence in order to conclude, as you would have it, that the inference cannot be sustained on the basis of the facts? Do you want us to do that?
Well, maybe yes. We have set out in our skeleton some of the key references to it, and I'll take you to that.
Was there any oral evidence?
No.
No. So the evidence we have is the evidence that there was.
That's it. So what as you will recall, with the claim form came the evidence, and saying, and that was it. We were given an opportunity to look at it and consider whether to put in our own evidence, and in the end, the decision was taken. No, that was inappropriate in the context of a Part 8 claim for declaration.
So you didn't put any evidence in or seek to cross-examine their evidence. So the evidence is what it is.
Exactly. Yes.
Thank you.
And the key evidence is well. Let me turn up our skeleton and the references in it. If the court goes to Core Bundle 1, tab 2 at page 35.
Well, just before we get into the detail of the evidence, can you help me on this? I would assume, unless you tell me otherwise, that it's not in dispute that any sewerage system must have some capacity. It cannot be possible to just design and build a sewerage system that has unlimited capacity. I would also assume that it wouldn't be in dispute that circumstances can arise, e.g. through climate change, where the flows in the system exceed, perhaps only exceptionally, but nevertheless from time to time, exceed the capacity for which the system was designed and built. Now, if those 2 points are accepted, where does the judge go wrong in characterising the result of those 2 points as being involuntary?
Because it suggests that in all instances, it was as a result. Let me put it another way. I would accept that the system has a limited capacity, and I would accept that there would be occasions where you had exceptional flows. It's not accepted that all of the spills that occur necessarily flow from those two matters. What the plainly, I mean, the course we took was, in essence, to try and drill down to the point of law in this case, because both sides accepted that it was going to be extremely expensive to look at flow by flow, outfall by outfall, and come up with some sensible assessment of that. But it doesn't mean that we cannot say to this court there are very significant elements about the system which one cannot simply describe as involuntary.
But the bottom line, therefore, seems to be, unless you tell me otherwise, that it's accepted that there will be at least some overflows which are involuntary. And your dispute amounts to this, that you don't accept that all of them are. But so what?
Well, that assumes that the declaration sought is that all flows from all outfalls which happen to be foul within the definition provisos are non-actionable.
Well, there conceivably may be a point on the wording of the declaration, but are you disputing the basic factual substratum for the question, which is that some of the outflows are involuntary, and there will be others where you say they're not involuntary, and you might say that they are involuntary, but, or at least on the way your side look at the case, that would require an expensive factual determination. Maybe you would agree with that if there's a real dispute about it. I don't know. But I just don't see where any of this takes us, except perhaps in terms of a question about the wording of the declaration.
But what? Well, yes, but where the line I draw is simply an assumption by the judge that all flows, all foul flows, are necessarily involuntary.
I've got that point. What I'm struggling with is where it takes us. Because your proposition is, as I understand it, he's wrong about that, but yet you accept that there are some which are involuntary. And therefore, so far as the question of law is concerned, you still are faced with a situation that at least some of the outflows are accepted to be involuntary, and then the question is, well, what's the legal consequence of that?
Yes.
We only avoid that legal question if it can be shown that none of the outflows are involuntary. But that's not your case.
No, it's not.
All right. I'm grateful for the clarification. I'm still slightly mystified as where that takes.
It doesn't essentially derogate from my main submission, which is that however so caused, it's in breach of the proviso, and we are subject to our version of what the provisos mean. We're entitled to bring a claim, whether in trespass or a nuisance.
Can you give us an example of what you would characterise as not involuntary, so as a voluntary use of the outfalls? No doubt you want to take us to the evidence, but I understand that you could have an allegation that an undertaker had negligently allowed foul water to pollute a canal, or deliberately chosen to pollute a canal when they had a choice. But those are excluded by this declaration.
Yes.
But if it's not negligent and it's not deliberate in that sense, in what sense is it? What factual scenario could be said to be voluntary, but not either negligent or deliberate in that sense?
Well, I can't answer that.
But all the declaration does is say, absent an allegation of negligence, absent an allegation of deliberate conduct, you don't have a claim. That's all it says.
Yes, to which I say, well, I may have a claim, and here are what the provisos say, and the provisos give me a claim. They give me a claim in trespass or a nuisance.
I see. Yeah. Thank you.
Would the court just give me a moment? Just give me a moment. I said I was going to just take you just show you the passages in the skeleton which deal with this. It's page 30, for bundle 1, tab 2, page 35. When we, para 62, we set out references from the Hazlitt's statement, and we make the point that the design and operation of the sewage system is controlled, and then after the quotations, all such discharge are regulated with calibrated conditions, paragraphs such and such. As set out above, these conditions represent the minimum acceptable standard for each discharge and are determined by the agency after full discussion. And then finally at 63, including the facts were indistinguishable from Marchich, the judge fell into where a discharge of sewers from a combined sewage outflow or overflow or similar outflow is an entirely different character from that escape of sewage onto land from an inadequately capacious sewage system. And more references at paragraph 66. This evidence did not suggest that the discharge of effluent from out was a purely involuntary act. And the final passage on this topic, in terms of the legal characterisation, paragraph 75, referring to the judge's conclusion that we have been debating. The judge sought to draw a distinction between a voluntary discharge without authority trespass and a discharge through the same network. There's no trespass. This is illogical. All the systems, drainage, treatment and discharge are deliberate. That's what you get paid for providing. Some operate at ordinary flows, some at extraordinary flows, which is when the overflows operate, or at least should operate. If the discharge of clean or at least non-foul water is a trespass, it's difficult to see how the policy of the law ought to be to characterise clean discharges as voluntary and trespass, and foul ones as involuntary and therefore not a trespass. Would the court give me a moment? Those are my submissions, unless I can help you any further.
Thank you. Thank you very much. Mr. Morgan.
Lady, if your ladyship would allow me a minute to get the lectern.
And find space amongst the screens for it.
Yeah, can't do without my screens. Lady, Lords, I have the appropriate first name for these submissions because this part of the appeal is very much seen as the tail end Charlie. Mr. Justice Fancourt described it as something of a loose end from the 2010 claim. But we say that it is nevertheless a significant point which must actually affect many discharges by undertakers other than United Utilities, as well as United Utilities, into private watercourses. There must be a lot of licenses out there. And actually we also say that that proposition that there are a lot of licenses out there, if accepted, is of course an indication that they performed a useful function. Because these licenses were entered into, particularly the 5 under consideration here, were entered into between people who knew what they were doing, a statutory canal undertaking, and local authorities who had long been in the business of sewage treatment and disposal, and who, by and large, should be assumed to know what they were doing. So, by way of orientation as to the appeal,
I'm sorry to interrupt you, Mr. Morgan. Could you elucidate for my benefit what exactly you mean by saying that they knew what they were doing? I mean, well, no doubt they knew what they were trying to achieve, but does your submission amount to anything more than that? I mean, for example, are you suggesting that they had some specialist legal expertise in this field?
No, I'm not suggesting that, but what I'm suggesting is that they should be assumed to be able to judge for themselves the adequacy of the way in which their needs were addressed by the agreements. In particular, for example, as to the length of notice required to determine them, and the acceptability of them being terminable upon notice. And what we say is that it is certainly not a coincidence that all of the discharges governed by these licenses are of an intermittent nature.
Well, again, can I just ask you about that? I mean, I can well understand a submission to the effect that in this country we have freedom of contract, save where statute provides otherwise, and that the law should not interfere with the freedom of contracting parties to contract as they wish. And any such interference must be rigorously justified. So that I can understand, but that's just a general proposition of contract law, isn't it? What's it got to do with the nature of the parties involved?
The significance is particularly the character of the local authorities, that they were in the business, as it were, under the statutory umbrella of the Public Health Acts 1875 and 1936, of providing and operating and using sewerage systems. So if on some occasions, and we are looking at 5 of them here, they consider the licensed arrangements under consideration to be appropriate, then in my submission there has to be a good reason for arriving at the conclusion that this is some unlawful exercise, either ab initio or because of the manner in which it is said to fetter the position in the future. These were, as it were, they are examples of the way in which the industry operated at the times that the agreements were entered into. The appeal is against the declaration at paragraph 1 of Mr. Justice Fancourt's order. That can be found in the core bundle tab 11, page 165. And that is in these terms, that notwithstanding the purported termination by the Canal Company of agreements or alleged agreements dated the 5th of September 1939, etc., United Utilities is and continues to be entitled to discharge water and or other matter into the canal from each of the 5 outfalls. So to a certain extent, this is a question of legal abstraction, in that, as the form of declaration indicates, whether the agreements are alleged or actual, as it were, whether in at least one instance they are the governing agreement, is not up for determination at this stage. The assumption to be made is that the agreements are the governing instruments. The matter is summarised in the agreed case summary and chronology. The summary of the agreements still in issue is to be seen at page 149 in the core bundle. Where in fact the 5 agreements, the subject of the declaration, are summarised.
There are 7 there. Which are the 2 which have fallen away?
Outfalls 132 and 136B are not before the court today.
Thank you.
And as that section of the agreed case summary makes clear, the reason for the determination of this preliminary issue is that if it is determined in United Utilities' favour, then it is dispositive of the claims. If it is determined in the Manchester Ship Canal's favour, then United Utilities will seek to raise a miscellany of other defences, including, for example, whether the agreements actually constitute protected business tenancies under the Landlord and Tenant Act 1954. I think it would assist to take your ladyship and your lordships briefly through the passages in the pleadings, and not least because there is a pleading point. If I can take you first to the re-amended particulars of claim, tab 18, page 225. I'm sorry, 222. One sees paragraph 16b(3), the 5 outfalls numbered, and those are the 5 outfalls, were the subject of contractual agreements which included an express right to terminate the agreement on notice, and express obligations upon such termination to remove the outfall and or sewer and reinstate the land and or to cease to discharge. These agreements were terminated after the 1st December 1991. The pleading then proceeds to address the discharges. There's a deleted paragraph, and then the heading outfalls and the 5 numbered outfalls, and then the heading A, express agreements which have been terminated, and the 5 are set out. One sees 1 on page 222, and then 2 on page 223, 3 on page 224, and 4 and 5 together at the top of page 225. But that tends to confuse the reader. One looks down at 5 and one doesn't see it because 5 is inside the same line as 4. To that pleading, the United Utilities responded by paragraphs 24 to 29 of the re-amended defence and counterclaim. The passage is found at page 248 in tab 19. And one sees at paragraph 24, by reference to a schedule, which I don't think it's necessary to take you to, the allegation of the agreements, and that they all relate to public sewers. And we certainly accept that each of the pipes in question became a public sewer. Paragraph 25 pleads as the suggested consequence of that, that at all material times after becoming a public sewer, the sewer to which each said agreement relates could not and now cannot be stopped up, save as authorised by statute. 26. The said sewers are essential to the operation of the system if the area which the system serves is to be effectively drained. Further, it is denied that it is practicable to provide alternative sewers which are equally affected. And then in the premises, in each of those instances, it's alleged at paragraph 28(1), the stopping up and or removal of pipes to which each agreement relates would put the defendant in breach of its duties under the Water Industry Act 1991, and the defendant has no power to stop up the sewers to which each agreement relates. And or 2, the defendant cannot lawfully consent or agree to the stopping up and or the removal of the pipes to which each agreement relates. Although I think that really should refer back to perhaps the actual parties to the agreement, who gave whatever consent they contain. If and to the extent that any of the agreements require the defendants to stop up and or remove pipes now constituting a public sewer, otherwise and in accordance with its powers and duties under the Water Industry Act 1991, such agreement is unenforceable. Then the reply is to be found at page 327.
I think that must be in the next volume.
Yes, I'm told it is. I'm sorry, I'm working off an electronic version which isn't in volumes. Yes, I can't easily
It's
see.
at, I think, at tab 21 in the next volume.
Tab 22.
22. You said 300 and?
Page 327.
That's at 21. Amended reply and defence again.
Yes, yes. Paragraph 13.2, as regards the outfalls, the defendant's right to construct the outfall to discharge water and other material into the canal was the subject of a contractual agreement. The agreements are particularised in the relevant amended annex. In each case, the agreement contained an express right on the part of the claimant to terminate the agreement on notice an obligation on the part of the defendant, again, or its predecessors, that upon termination it would remove the outfall and or sewer and reinstate the land and or cease to discharge as set out in paragraph 16b3 of the re-amended particulars of the claim. The claimant has served the requisite contractual notice to terminate, but the defendant has failed in breach of its contractual obligations to reinstate the land and or to cease the discharge. Accordingly, the continued use of the outfall for discharges by the defendant is a trespass. And certainly it's a fact that since those terminations, now quite a number of years ago, the discharges have in fact continued. So, as the court was made aware in the course of Mr. Hart's submissions, there is a clear distinction to be drawn between continuous discharges, usually of treated effluent from wastewater treatment works, and intermittent discharges from outfalls which bear various names according to their specific function, combined sewer overflows, surface water sewers, etc., all of which either relieve the system in an emergency or carry away rainfall when it happens, but are doing nothing when it does not.
These are all intermittent ones?
Yes.
And they're all stormwater out?
I think 3 of them are described as surface water. The descriptions of them vary depending on where one has recourse to find them. Mr. Karras will no doubt correct me if I'm wrong, but I think I'm right in saying that they are either combined sewer overflows or stormwater overflows.
Yeah, that's correct.
Yes, thank you. We're agreed on that.
So the combined ones will carry foul water, but the surface water ones don't?
Well, I mentioned surface water sewers, but I don't think we are in fact concerned with this. Yes, there is a schedule which describes 2 of them as surface water sewers, and 3 of them as combined sewer overflows. But I think, in fact, if one looks at the agreements, they're referred to as...
265. Yeah, 265 is the way we've described the pleadings. In the schedule.
Well, if I can take you to the schedule we're talking about, it's at page 265, and it's a schedule to the re-amended defence and counterclaim. I hope it's legible. But it contains the 5 outfalls. You see the numbers in the left-hand column, 23, 26, 36, which has 2 entries, and sorry, 35, 36 and 67, yes. And then in the 4th column, the heading is type of discharge. 3 of them described as SW and 2 of them as CSOs. In the bottom left-hand corner is a legend which says that SW equals surface water and CSO equals combined sewer overflow.
But your argument doesn't depend upon any difference between clean water and foul water.
No. No, that we've left that important distinction behind, as it were, for present purposes.
But that's why your argument is based on trespass. It's not based on nuisance.
Well, in relation to these flows, the argument would be that these are trespasses because on our case they are permissive and permission has been withdrawn.
Yes. Thank you.
So obviously one consequence of the distinction between continuous and intermittent flows is that if a continuous flow were to be stopped, then obviously there is an immediate problem, as it were. And we say it's no coincidence that none of these licenses relate to such flows. Now, if an intermittent, if discharge is legally halted, it doesn't follow that there will be any immediate effect. And it may assist if I interject into my own submissions at this point that, of course, in the Supreme Court in 2014, no such distinction was drawn, because the proposition that Lord Sumption relied upon was that basically if there was no implied right of discharge, then the whole system would grind to a halt, as it were. But there was no discussion in the Supreme Court about any distinction to be drawn between continuous and intermittent discharges. If I can put it this way, it was recognised as being, as it were, an Armageddon situation. And Outfall 26, there's a summary to our skeleton argument at page 497. I'm sorry, it's at I'm using the wrong reference there. It's page 101. This was a schedule to our skeleton argument seeking permission to appeal. It actually summarises one agreement which is not actually under consideration for present purposes, which is at the top of page 103. But this summarises the actual text of the agreements, which I won't take you to unless you wish me to, because they are rather illegible. But you'll see that Outfall 26 is an agreement of the 2nd of March 1916 relating to, in paragraph 1, a storm overflow.
I'm sorry, I must be on the wrong page. You took us to 103.
What? Sorry, 103 is.
And I got to the top of that, Outfall 36.
Yes, that agreement is not one of the ones that is presumed to be in play. And we then go to 101, the start of the schedule.
Okay, I'm sorry.
And this is another outfall at Stockton, number 26.
This is 26, yes.
2nd of March 1916, and in its own words, it relates to a proposed discharge from a storm overflow. At the bottom of the page, Outfall 67, Eccles, 24th of April 1933, and at paragraph 7, that relates to a proposed discharge from a stormwater overflow sewer. The third one, as I say, we passed by, and then on page 104...
Does this show us anything more than we had in your table with the column which had SO and...
It seems to be slightly at odds with the schedule in terms of whether there's surface water or stormwater. Because we see that Outfall 23 on page 104, agreement of 5th September 1939, does relate to a surface water overflow, paragraph 71. Outfall 35 on page 105, agreement 24th of June 1955, paragraph 21.1, that's a stormwater overflow sewer. Outfall 36 on page 106, agreement of 17th November 1987. And there's a note there that there is a disagreement about whether this is the correct agreement at all. As I understand it, the disagreement arises because what happened was somebody went along the bank and spotted outfalls, and they then had to be matched up by reference to their physical locations to agreements. And so many things had happened over so many decades that in some instances there is room for argument about which outfall is which, as it were. But in this case, there is a disagreement. But at paragraph 27, it's noted this relates to proposed discharge of sewage and storm water through an outfall. So that's a storm water overflow. And that schedule also summarises the terms and conditions attaching to these licenses, which essentially license two basic things. Firstly, entry onto the land and the laying of a pipe, and secondly, the discharge of the intermittent flows out of the end of that pipe into the canal. The size of the pipe is stipulated, and numerous other conditions, in particular conditions which seek to regulate the quality of the flows in some cases. For example, by stipulating the degree of dilution that must be achieved before overflow occurs. And these are things that are usually achieved by the careful setting of weirs which allow an overflow. The higher the weir, the more water there will be in the pipe before the overflow occurs. Therefore, the more dilute will be the escaping contents. These and many other matters are legislated for in some detail in some of the licenses. They're all about quite significant pipes in size, and they use a varying language to describe the nature of the grant. They are all determinable on notice of either 6 or 12 months. So the question which is raised by the preliminary issue is, in effect, are agreements of this nature lawful, or whether one stigmatizes them as unlawful or not taking effect according to the terms, are they instead now just a version of a perpetual right of discharge? And in a nutshell, what we say is that the argument that says that they've now, and indeed we're always incapable of termination in accordance with their terms, is really seeking to convert a precarious grant into a permanent deprivation of a property right. Mr. Hart's already taken your ladyship and your lordships through the legislative provisions starting in 1875 in some detail, but I'm afraid I would wish, albeit swiftly, to do so again, looking at it through the different lens of this issue. We begin with the Public Health Act 1875. And the first provision to which I would draw the court's attention is the power in section 16, described as a power for making sewers. This is an early version of what's usually called the pipe laying power. Any local authority, this is at page 30 in the legislation bundle, tab 3. Section 16, powers for making sewers. Any local authority may carry any sewer through, across or under any turnpike road or any street or place laid out as or intended for a street, or under any cellar or vault which may be under the pavement or carriageway of any street. So that's streets. And after giving reasonable notice in writing to the owner or occupier, if on the report of the surveyor it appears necessary, into, through or under any lands whatsoever within their district. And that and all later versions of the power are predicated upon the giving of notice. It's a requirement to invoke the pipe laying power. The court's already seen section 17, which contains the proviso, foul water proviso, and section 18, the continuity duty, as I might call it. You may discontinue the use of a sewer, but only if you provide another. And at section 21, an early version of what is usually termed the right to connect, or the right to communicate with a sewer. We then move forward to section 327, which is at page 37. And this is new, as it were. We haven't been taken to this yet, because these are protective provisions for particular forms of undertaking. And it begins, nothing in this act shall be construed to authorise any local authority, familiar words. And then subsection 1 is to use, injure or interfere with any sluices, floodgates, sewers, groins or cedar fences or other works, already or hereafter made under the authority of any commissioners of sewers, or any sewers or other works already or hereafter made and used by any body of person or of persons for the purpose of draining, preserving or improving land. Then in 3, no authorisation to interfere with any river, canal, dock, harbour, lock, reservoir or basin, so as to injuriously affect the navigation thereof or the use thereof. And 4, no authority to interfere with any watercourse in such manner as to injuriously affect the supply of water to any river, canal, dock, harbour, reservoir or basin, in cases where any such body of person or persons as last aforesaid would, if this act had not passed, been entitled by law, etc. And 6, to execute any works through or under any wharves, quays, docks, harbours or basins. I can take you to the provisions which support my submission to the court that the Manchester Ship Canal Company is, within the meaning of these terms, a dock undertaker. I don't know if learned friend requires me to demonstrate the correctness of that proposition.
Yeah, we haven't looked at it.
Thank you.
We haven't looked at it.
Right. Well, my learned friend says he hasn't looked at the point. I'll not take the court's time with it at the moment. And section 328 provides for the reference to arbitration of various disputes in the case of works not within the preceding section. If we can then move forward to the Public Health Act 1936, which is at tab 4, the first provision to look at there is section 15, which is at page 41. that is a version of the pipe laying power, and in subsection 1, paragraph 1b, again, power is given to construct a public sewer in, on or over any land not forming part of the street, after giving reasonable notice to every owner and occupier of that land. And if one doesn't give that notice, one is a trespasser. And I would also draw the court's attention to little 3, Roman 3 there, to which I shall revert later. There is also a power given by agreement to acquire, whether by way of purchase, lease or otherwise, any sewer or sewage disposal works, or the right to use any sewer or sewage disposal works. Because it has been suggested that these licenses must amount to an exercise of the pipe laying power. We suggest not. We suggest that, unsurprisingly, people undertaking sewerage endeavours have always been given powers by agreement as well. Section 22 on page 46 is the right to alter or close public sewers, again subject to provision of an alternative. Section 30, you have seen the foul water proviso. Section 34, the bottom of page 48, is the right of communication. And I would draw the court's attention to, in the proviso to that section, going over the page to page 49, there are 3 provisos. And the third is that nothing in this subsection shall entitle any person to have his drains or sewer made to communicate directly with a storm water overflow sewer. So all the sewers that are the subject of these licenses, with the possible exception of the surface water sewer, could never be the subject of a direct connection. I certainly recognise that they will be downstream of such connections, but there is no question of direct communication with these overflow sections. Section 333, which is on page 56, provides protection for the works of dock undertakers and for railways. And section 343, the interpretation section on page 58, provides at page 59 a definition of dock undertakers. I might as well take you to it now here. On page 59, just below the top, dock undertakers means persons who are statutory undertakers in respect of a dock, harbour, canal or inland navigation. And then on the next page, statutory undertakers is defined about halfway down. Statutory undertakers means any person authorised by an enactment or statutory order to construct, work or carry on any railway, canal, inland navigation, dock, harbour, tramway, etc., or other public undertaking. In 1973, the Water Act of that year transferred sewerage functions to the regional water authorities, and I shall simply mention for continuity in passing section 14, which is in tab 6 of the legislation bundle, page 68, which contains a number of now familiar provisions, effectively shifting the general duties over to the regional water authorities in a manner which addresses in my submission all the relevant sections that I've taken the court to so far. Then we arrived at privatisation in 1989, and I think the learned leader took you to Schedule 2, at any rate. If I can first of all take you to page 95 in the bundle, which is that is Schedule 2. Schemes providing for the initial transfers. Each of the water authorities shall make a scheme under this schedule for the division of all their property rights and liability between the successor company and the authority, and then under that, schemes were made, and I think you've heard reference to these schemes which transferred rights and liabilities. I don't propose to address them in any more detail at the moment. Then
so each water authority had one successor company that inherited its undertaking.
Yes.
And how many water authorities were there? 10?
Approximately 10. Yes. At page 100 is Schedule 8, sewerage functions, made under section 69, and that transfers functions, including those under the Public Health Act, to the private undertakers. So at that point, nearly all of the relevant provisions of the Public Health Act 1936 continued in force. Then we come to 1991 and the Water Industry Act, and that, the court's already seen section 106, the right to communicate with the sewer, which is at page 200 in the bundle. I'll take the court to that MMA simply to point out that once again, in subsection 2, one sees nothing in subsection 1 above shall entitle any person, and then we go over the page C, to have his drains or sewer made to communicate directly with a stormwater overflow sewer.
I'm sorry, which section was that?
Section 106,
Thank you.
subsection 2C. And then we have section 116 at page 227. Power to close or restrict use of public sewers, which begins with a permissive provision, a sewage undertaker may discontinue and prohibit use of any public sewer, subject to various provisos, of which over the page include 3. Before any person who is lawfully using a sewer for any purpose is deprived under this section of the use of the sewer, the undertaker shall provide another sewer equally effective. So we say that it certainly by no means follows as night follows day, that the discontinuance of the use of an overflow somewhere, possibly a long way down the system, automatically amounts to the deprivation of the use of the sewer by anybody. The effect it might have, of course, is similar to the facts of Marchich. One acknowledges that there might somewhere else in the system be an unintended relief of the system, but only in extreme circumstances.
Sorry, I've not understood that submission. Is your submission that a person who connects into a sewage system, and the system includes somewhere downstream a combined overflow,
Yes.
is not using the combined overflow? Looking at subsection 3, is that a person lawfully using that sewer for any purpose?
They might be said to be using the overflow in the sense that they are part of the beneficiaries of its existence. But its non-existence would not deprive them of the use of their communication with the sewer. The point
I've not understood. Sorry, Mr. Warden, I'm being very slow. A new house is built. It has a right to connect
yes,
under section 106.
yes,
So it gives the appropriate notice. It connects into UU's system.
yes,
Most of the time, the sewage from that house goes into the sewage treatment plant and doesn't cause any problems. It doesn't go through the overflow because the overflow is for exceptional circumstances.
yes,
But in circumstances of heavy rain, we know that the overflow is used to carry off surface water and some untreated sewage.
yes,
And it might include some untreated sewage from that particular house.
yes.
Is the householder a person lawfully using the overflow for any purpose within the meaning of subsection 3?
Yes, I'm prepared to accept that they are. But
And then
not-
if you shut off the overflow,
yes,
are you depriving that person of the use of that sewer for that purpose? I think your answer was no, but I don't understand why.
If one looks at just that section, yes, but what one is not depriving that person of is a communication with the sewer.
Well, they're still plugged into the system, but
Yes.
the system no longer has that outflow because it's been stopped.
Yes,
What subsection 3 says is the sewage undertaker cannot deprive that person of the use of that sewer for that purpose without providing another one that's equally effective. Unless I've misread it.
well, the point I'm seeking to make is that in terms of the consequences, there's a great distinction to be drawn between saying to somebody, your connection is cut off, your house is now discharging its sewage into a cork in your pipe, and the situation when, some distance away, an outfall is removed, which I have to acknowledge, of course, it might try to discharge today, but it might not discharge for many weeks. And even if it does, even if that outfall is blocked, and even if there is some difficulty with the system, there will normally be no noticeable consequence at that person's new house.
So you're saying because it may never arise, there may never be a sudden downpour, which means that one has to rely on that overflow, because it may never arise. Another way of calling it intermittent.
Yes.
And it may never happen. And because if it does, there's the possibility that the slack will be taken up elsewhere. That accordingly nobody has been prevented.
Yes, my lady, yes.
In
And
effect.
to use the language I used earlier, it is not Armageddon. Because this is very relevant to how far you must take the reasoning behind Lord Sumption's implication. which was based on the effect of Section 116 and Section 106. Allow me one moment. So if I may then turn from the legislative provisions to the case law. The Supreme Court in 2014 was pressed with the argument that without a right of discharge, which necessarily, if it existed, was going to be found by implication, because there was definitely no express right, then the entire operation of the sewerage networks of England and Wales would be rendered unlawful at the moment that the Act came into force. So all discharges, both intermittent and continuous, would be unable to find any power. Now, in the case of the licenses we are considering, the opposite was prima facie true. Because a right could be found without recourse to any implication. The right expressed in the agreements themselves. Which rights would have passed to the undertakers in 1989 through the transfer schemes. And it's because of that that the Supreme Court was very careful not to express any view on the position of such licenses, and we see that in paragraph 23 of the judgment of Lord Sumption at tab 63, page 1139 in the authorities bundle. I'm sorry, Nick, is that bundle 5? Yes, 2.5. It's his conclusion. I would accordingly allow the appeal to the extent of declaring that, subject to section 1175 of the Water Industry Act 1991, we've already been there, the defendant is entitled to discharge into the claimant's canals from any sewer outfall which was in use on or before the 1st of December 1991. Well, of course, that generality is apt to describe these licenses, but Lord Sumption continues, for the avoidance of doubt, I should make it clear that this in no way affects any binding agreement under which the parties may have regulated for themselves the use of particular outfalls. We were informed that there may be such agreements with some proprietors, but we have not been concerned with them. Now, Mr. Karras effectively says, well, that's a distinction without a difference, because the force of Lord Sumption's reasoning is equally applicable to such licenses as it is to the general run of things. We say not so. We were certainly encouraged by a remark of Mr. Justice Nugee at an earlier hearing, which is referred to by Mr. Justice Fancourt in his judgment at paragraph 92.
Do we have Mr. Justice Newee's judgment?
Yes, it's tab 12 in the core bundle,
Thank you.
page 100. Well, there's an extract from it within the judgment of Mr.
we don't have
Justice
the
Fancourt. I'm sorry, you don't have the whole judgment of Mr. Justice Nugee. I'm just taking you to the extract from
Yes.
Mr. Justice Fancourt's. It's at page 197, paragraph 92. At the bottom of the page, in his judgment granting UU summary judgment on the right to continue to drain from pre-1991 outfalls into the canal, Mr. Justice Newey explained why the decision of the Court of Appeal in BWB did not preclude its conclusion. He commented as follows at paragraph 50, which is why I think somewhere in the papers you may see this part of the case referred to as the paragraph 50 issue. So it's paragraph 50 of his judgment in relation to the argument on which UU succeeded before him. I doubt whether Mr. Carris's argument could have helped the defendant in BWB. The licence pursuant to which the defendant and its predecessor had been discharging could be brought to an end on 6 months' notice, because BWB was about the licence. While the point has not been the subject of argument, my provisional view is that any right to discharge which the defendant or its predecessor might have derived from pre-1991 legislation will not have endured beyond the licence. If that is right, the defendant had no option but to found its case on section 159 of the 1991 Act. And we say that remark on further consideration, which is now taking place, is well founded. We are at the opposite end of the spectrum from the Armageddon scenario that was painted to the Supreme Court as the argument about what would happen at midnight on the 1st of December 1991 if no implied right of discharge existed. Because the suggestion was, well, one of two Armageddons is going to occur. Either the new undertakers are going to realise that they are going to act unlawfully and are going to be so shocked at the possibility that they are going to flick the switches and turn the entire networks of England and Wales off, or they are going to carry on, in which case, as it was perceived in 2014, they would become immediate tortfeasors on a grand scale, because they would be trespassing and committing nuisances all over the place. Mr. Carris now says not so, or certainly not actionable ones. If we now look at the licences, we're at the opposite end of that spectrum. As I've said, there's no immediate or even certain loss of the entitlement to discharge. They wake up the minute after midnight and they've still got these licences. Nobody's determined them. None of them are in the course of a notice period or anything like that. There is no loss of any ability to make any discharge, intermittent or continuous. And as I've already said, no certainty of any immediate deprivation of people's use of a sewer if it does occur. So our submissions are essentially that until the 1st of December 1991, the discharges were being made pursuant to the express rights granted in the licences and not pursuant to any implied right of discharge. Those contractual rights passed to UU under the transfer scheme in 1989 And after the 1st of December 1991, the licences continued. And UU derived the benefit of the rights that they granted. And there is simply no room for implication in the face of those express rights. So addressing the first of those propositions, that discharges until 1991 were made pursuant to the express rights. The first and obvious point is that that was precisely what the agreements were all about. That was their purpose. And then we say there was consequently no need for any implication. The implied right which was held to exist in Durrant and Branksome UDC in the case of discharges made under the Public Health Act 1875 was found to be based upon the power to lay pipes and the inference to be drawn from the foul water proviso.
Section 16 and 17.
Yes. Until that power to lay a pipe was exercised by notice, it was, we say, inchoate. In one sense, the local authority could be said to possess the power in relation to every inch of every water bank everywhere within their jurisdiction. But in a more realistic sense, they didn't possess the power anywhere until they served notice and laid a pipe. Now, there's no suggestion that that occurred in any of these cases, nor would it need to. So there's no basis for implying any right, and certainly not the right that was declared to exist in Durrant and Branksome. Now, as for the position in 1989...
Sorry, before you leave that,
Lord.
your submission is that these 5 pipes were not laid pursuant to the power in Section 16 and its successor in the 1936 Act.
Yes. They were laid by agreement, and we can...
These are local authorities.
Yes.
It's a fundamental principle of public law that local authorities only have powers conferred on them by statute. They don't have
Yes.
inherent powers. So what power did they have to lay a pipe by agreement if it wasn't Section 16?
The powers that I took your Lordship to earlier, Lordship, bear with me, under the (1875) Act, Section 14. I'm sorry, I may not have taken you to the 1875 version. Section 14 on page 30.
Yes.
Any local authority may purchase or otherwise acquire from any person any sewer or any right of making or of user or other right in or respecting a sewer, with or without any buildings, works, materials or things belonging thereto, within their district.
So you say they were acting under the power in Section 14.
Yes. In the case of the licences entered into before the coming into force of the 1936 Act.
That looks, partly because of the head note, but partly because of the wording of it, it looks like it confers a power on the local authority to buy things from other people.
Including rights.
May purchase from any person any right of making a sewer. So it looks as if what it's doing is where somebody else has a right to make a sewer and the local authority acquires it from them.
Well, in my submission, the words are capable of including the right to make a sewer on somebody else's land.
So purchasing from the canal company the right to make a sewer
Yes,
on the canal company's land.
yes.
Okay.
In my submission, it's certainly a provision that should be construed widely, because one would expect to find such a provision, as well as powers that can be exercised unilaterally. One would normally expect to find in a public law statute of this nature a power to act consensually, and here it is.
Before entering an agreement with the canal company to make a sewer on the canal company's land, they must have given notice to the canal company saying this is what we want to do.
But
So why are they not exercising the powers in Section 16?
well,
finding this
because
quite
they go
difficult.
about it in a different way, because what they did was enter into an agreement. Whether they served notice in a form that would constitute the giving of notice under Section 16 is unknown, as it were, but there's no reason to suppose that they did. In fact, the fact that they entered into the licenses is strongly suggestive of the contrary, but as I shall go on to submit, all we can do is identify the context in which the licenses were made.
Yes, okay.
Well, is it something to do with it being a waterway? Because Section 16 is talking about any turnpike road or a street or place laid out as or intended for a street or any cellar or vault. Doesn't seem, on the face of it, to apply to waterways.
No, my lord,
Whereas, yes, go on.
it's the last line. Or into, through, or under any lands whatsoever.
Right, okay. So you would accept that includes a waterway?
Well, the pipes went under the land alongside the waterway in the ownership of the Manchester Ship Canal Company.
And so you're saying this covers the laying of the pipe in the riverbank or the canal bank,
Yes,
rather than the actual outflow into the canal.
yes.
Yes, I'm sorry to have interrupted you.
That's very helpful, lady. And what has been said is, well, by reference to Section 16 and 17 together, one comes to the conclusion that having reached that outfall, a right of discharge, a power of discharge is to be implied. But in my submission, we simply don't get to that point in the abstract sense, because it's all done by agreement. My learned friend has countered our argument with the proposition that it had to be the pipe laying power because there was no other way the local authority could go about it. We say, yes, there is. Look at Section 14.
Yes, and presumably you would say that doing it consensually has the advantage, apart from anything else, that avoids disputes and hence litigation.
Lord, yes.
If the local authority relies upon its powers under Section 16 and 17, it may be held to be exercising those powers lawfully, but there's always a risk that it might be held not to do so, and therefore there's an advantage to the local authority in doing it by contract.
My lord, yes, precisely. And indeed, the power under Section 159, the successor to Section 16, is indeed a very rough and ready thing, and does cause disputes. And I might add, I think it appears to be uncontested that if the power is not exercised properly, then the acts constitute a trespass.
Can I just check? Does this part of your argument depend upon the sewers not having been made under Section 16? Or do you say, well, even if it was made under Section 16, it was made consensually, so there's no need for an implied...
Yes, I can put it that high. Yes, I think I can. Because implication is a tool of, if not last resort, certainly not first resort.
Yes.
And what Mr. Karras is asking the court to conclude is that the implication is unavoidable. You can't act any other way. In a sense, in essence, what we're saying is it never arose and it will never arise in these circumstances. The equivalent provision in the Public Health Act 1936. Yes, it's section 50, it's at page 41 in the Authorities Bundle legislation. Section 15, subsection 1, little Roman 3, at the end of the section. A local authority may, by agreement, acquire, whether by way of purchase, lease, or otherwise, any sewer or the right to use any sewer or sewage disposal works.
Now, that's not confined to the right to use someone else's sewer, but you say includes the right to use their own sewer by discharging.
Yes. And we say that this analysis is coherent. Lord Sumption used the adjective incoherent to describe the arguments that sought to defeat the general implication that was under consideration in 2014 in what I've termed the Armageddon situation. But there is no such incoherence in these circumstances. What is, in my submission, incoherent in comparison is the notion that really all this patient effort by gentlemen with quill pens in local authority offices up and down the country was just a complete and utter waste of time. And they didn't know their own business.
I do think typewriters have been invented by the times of these agreements, but that's by the by.
Yes, I think they are all. One of them may be handwritten. I think one of them is handwritten, my lord. And the ones that are typewritten certainly don't compare to a modern Canon printer.
Yeah, well, that's the problem with carbon copying, apart from anything else.
Yes. I'm sorry if you could just bear with me while I reorientate myself in my own notes, because I went back to the authority of power to do things by agreement. Yes, in the judgment of Lord Newburger in the Supreme Court in 2014, you will see at paragraph 67 to 70 analysis of the effect of the transfer schemes. This is at page 2.5, is it? 2.5, page 1148. Although I'll return to this later, but the whole of that section of Lord Newburger's judgment is described, in my respectful submission, intriguingly, as an alternative approach, which would only arise if the approach of the majority of the court was wrong. So he agrees. Sorry.
This is a majority decision.
Yeah, well, that's the intriguing thing, that it is also itself said to be a majority decision, but it remains expressed only in Lord Newburger's judgment, and only in terms which described as being alternative to the main ratio decidendi. And if the main ratio decidendi stands, then the alternative doesn't arise. If I may, I'll revert to that. Essentially, what he does conclude is that whatever the local authorities, or by then the regional water authorities, had in 1989, would pass to the statutory undertakers under the transfer schemes. And certainly we adopt that argument. But what we say was transferred was not the implied power of discharge per Durrant and Branscombe, but the rights under the licenses. So the next step then is what happened on the 1st of December 1991. We say that...
Just before you move on, can I just go back on something you said? If you had two powers to do something, one under statute and one by agreement, and they're not inconsistent, they're both entitled you to do the same thing, is there any reason why you shouldn't enjoy both rights?
Well, when one can only be exercised by a unilateral notice, it's simply, you haven't exercised it.
I see.
You simply haven't.
Yep. I see the way you put it.
Presumably you'd say here also they are mutually exclusive, because if you gave your unilateral notice, you'd be unlikely to be going to the lengths of the terms of the licence.
Yes. And of course, if one were dealing with a contract, then far from accepting the proposition that an implication could run alongside an express term because it was consistent, one would be saying, well, there's just no need for the implication. You don't need an implication where you've got an express term. Now here we're looking at a situation where there is a statute and a contract, but the point remains the same one, that implication is an interpretive tool, and there's no need to resort to it to explain what's going on and to justify what's going on.
Yes.
So you're taking, it's now the 1st of December 1991?
Yes, and midnight has chimed. And we say that nothing happens, that everything just goes on as normal, the licenses remain in force, and United Utilities continue to enjoy the rights under them that they have been enjoying since 1989. Now, the only other possibility, if the court is with me that far, then, so we get to midnight on 1st of December 1991 and the licence is prevailing, then the only other possibility to the licence continuing to prevail is that the general implied term kicks in as per the Supreme Court in 2014. If that's right, then there has been a quite significant deprivation of the Manchester Ship Canal Company's property. And Lord Newburger at paragraph 58 had something to say about that in general terms, at page 1146 in bundle 2.5. Bundle 2.5.
It's bundle 2.4, I think.
I'm sorry, is it?
No, you're right. I'm sorry, 2.5. 1147.
1146, my lady.
Thank you. Paragraph.
58.
Thank you. Sorry about that.
The question whether sewerage undertakers can claim any rights in respect of any outfalls must ultimately turn on the 1991 Act. But in my view, the issue should be addressed by first identifying the Water Authority's rights in respect of outfalls from public sewers immediately before the 1989 Act came into force. Mr. Carris's argument is that it is a necessary inference from the terms of the 1991 Act that sewerage undertakers have a right to discharge from existing outfalls. A court should not be easily persuaded that a new right has been created by implication, particularly where that right, 1, interferes with the private rights of third parties, in this case waterway owners, and 2, arises out of a long and detailed statute. There is, in my view, a strong presumption that 1, private rights are only to be taken away by a statute by means of clear and specific words, and 2, where a statute deals in considerable detail with the rights and obligations in a certain field, it is intended to be exhaustive, particularly where the legislation is both consolidating the law and giving effect to Law Commission recommendations. And Lord Toulson, to similar effect, of paragraph 37 at page 1141. Albeit it's expressed in the context of supporting the position of the undertakers, but the principle is the same. Second sentence, if, as I have concluded, sewerage undertakers did not commit the tort of trespass between 1989 and 1991 by continued use of public sewers vested in them under schemes made under the 1989 Act, Parliament cannot be taken to have intended to change that position by the 1991 Act. Well, as it were, what's sauce for the goose is sauce for the gander.
So I haven't quite understood the significance of 1st December 1991. The transfer schemes took place under the 1989 Act at some stage between 1989 and 1991.
Well, that is correct. The significance of the 1st of December 1991 is that that is when the relevant sections of the Public Health Act 1936 became repealed and replaced by the new provisions of the Water Industry Act 1991. It was an awkward overlap. The privatisation was in 1989, but I don't know whether for want of time to do it or for what reason. The 1936 Public Health Act carried on. So there was a Water Act 1989, but it didn't cover the whole of the ground that the Water Industry Act 1991 and the Water Resources Act 1991 eventually covered. So there was a sort of interregnum when you had the new undertakers, but the old statutory powers.
I see.
So therefore the Durrant-Branscombe implication continued where it existed.
The Durrant and Branscombe implication arose from the Section 17 proviso
In the 1875 Act.
in the 1875 Act, which was continued in the 1936 Act,
Yes, Lord.
but was not continued into the 1991 Act.
No.
Why wasn't it continued by the provisos that your leader relied on?
Because, for the reasons given in BWB and Severn Trent, by what I think probably was an accident of drafting, what had previously been two separate sets of legislative provisions, one about water pipes and the other about sewerage pipes, became elided into one pipe laying power in the 1991 Act. And unfortunately, only water companies with water pipes were given an express right of discharge. So for that reason, in BWB and Severn Trent, it was held that you could not imply a right of discharge from sewer pipes for that and other reasons. So unfortunately, as it were, certainly from the point of view of the companies, you could not carry forward the reasoning from Durrant and Branksome UDC. The proviso was not applicable. I can take the court to the nitty-gritty of this if need be, or possibly write a note overnight about it. But I think it's probably common ground that there was no prospect of the implication process in Durrant and Branksome being carried forward to the 1991 Act.
My lord, or my lady, that is indeed common ground. The position was that under the 1991 legislation, the provisos in terms only applied to a certain number of provisions. They did not apply to the pipe laying power, therefore there was not scope for the linguistic implication as described both in...
Is this all dealt with in the 2014 Supreme Court?
It's briefly described by Lord Sumption. He describes it as, under the old legislation, as a matter of linguistic implication. There was no scope for that linguistic implication under the new legislation because the proviso didn't apply to the pipe-laying powers. That's the essence of BWB.
But there's no dispute about that.
There's no dispute. Well, we can't dispute it any longer.
Yes, so on that matter at any rate, we are at one.
So we're still at midnight, or perhaps it's just gone midnight, on the 1st of December 1991.
Lady, yes. So what we say is that in the case of these licenses, there is simply no need for the robust solution that implication achieved in relation to the wider problem.
And they just carried on, the licenses just carried on?
They carried on until they were determined by notice according to their terms. I propose next to address the court on the Byries question and fairly briefly on the authorities which are cited in our skeleton arguments. The first point we make is that when the agreements were entered into, they were not fettering any existing established right. There was no implied right to discharge from those points through any pipes. So it cannot be said that the agreement fettered any existing established right. It created new consensual contractual rights. Nor did it prevent the future assertion and exercise of any inchoate right, as I call it. It was a mutually beneficial agreement, and some support for that can be derived from the judgment of Lord Justice Chadwick in the British Waterways Board case, which is in the Authorities Bundle 2.3 at page 500 and tab 50, page 596. The passage I'm referring to is at page 610. Because in British Waterways Board and Severn Trent, as the course has already heard, that was actually a case about a determined licence, interestingly. What Severn Trent Water sought to say was, oh well, and this was after 1991, they sought to say, oh well, it doesn't bother us, we'll just invoke our implied right under section 159, as per Durrant and Branscombe UDC under the earlier legislation, held no such implied right. So the licence is terminated and you do not have an implied right on the only basis on which you seek to assert it. Page 610, in paragraph 48, the end of, I'm sorry, paragraph, yes, 48. Last sentence, Lord Justice Chadwick says, it is not, I think, open to doubt, nor is it in dispute, that the Water Authority entered into the licence of the 22nd of April 1976 for the purpose of enabling them to perform the duty imposed by section 14, subsection 1 of the 1973 Act, which is the duty of effectual drainage, as it then stood. This is now section 94. We also say that there is the additional context here, and indeed it would have applied on the facts of BWB and Severn Trent as well, that MSCCL, the Canal Company, was, it wouldn't have an L in those days, was the owner of a canal and therefore entitled to those extra protective provisions in the 1875 Act and then the 1936 Act, which I identified earlier. So it was a much more attractive and sensible approach to engage in the consensual method of a licence, rather than entering into a tangle of unilateral exercise of implied rights and arguments over whether injurious affection would result. It's a case of saying, well, let's all be nice and cooperative and agree about this. And that is how we put it in our skeleton argument at page 87, paragraphs 10 and 11. They contain conveniently together the provisions of the 1875 Act.
Can I just ask you about injurious affection?
No, I'm sorry?
Can I just ask you about injurious affection?
Yes.
If the sewerage undertaker in 1916 had unilaterally exercised its rights under sections 16 and 17 of the 1875 Act, it would have been liable to pay compensation under section 308, is that right?
Potentially, yes, if injurious affection had resulted.
Would you not pay compensation whenever you used someone else's land?
In respect of any diminution in value of the land due to the presence of the pipe under it, yes.
But you wouldn't simply pay compensation for compulsorily acquiring the rights. I mean, having a pipe under your land may not cause you any actual injury at all, but apart from statutory authority, you'd be entitled to charge a way leave for it.
Yes.
So would the landowner be entitled to compensation under Section 308 if the...
Well, this landowner, as a dock undertaker, would have been able to go further if it could make a reasonable assertion of the possibility of injurious affection. It could say, you need our consent.
But the point my Lord is making is a slightly different one. Namely, it's a property right, and therefore you have Lord Nichols's user right basis for a claim to damages. That is to say that where your property is used by another without your consent, you are entitled to damages quantified as being the licence fee that you could have charged for granting your consent.
Well, yes, the Whaley basis would be applicable. The cause of action would be trespass.
Indeed, it would. You're absolutely. The cause of action would be trespass, but it's no answer to say, well, you don't suffer any damage to the land because you're entitled to charge for your use of property. This is what we nowadays call negotiating damages.
Not yet.
So if I go back to my question, suppose an undertaker had, in exercise of the powers under Section 16, given reasonable notice and then unilaterally laid a pipe in the canal company's land, ending in an outfall into the canal. By Section 17 and Branscombe, they would have been entitled to use it.
Yes.
Would the canal company have been entitled to compensation under Section 308 for damage thereby caused?
Which would allow me to look at Section 308.
Lord, if I can assist, it's common ground that in those circumstances, if there was injurious affection, there would be a claim. That would normally be on the diminution in value basis, applying the usual application of principles to compensation for injurious affection found in compensation law.
I would have thought there would be an argument for the landowner to say, regardless of injurious affection, it doesn't actually affect me at all having a pipe under my land and surface water put in my canal. It's probably a good thing.
Well, in some...
But you've used my land compulsorily under statutory powers. Had you not had the statutory powers, I could have charged you for it. Why can't I charge you? Why can't I claim compensation under the Act for the fact you've taken my land?
Well, because under the pipeline powers, one is authorised to construct and implicitly to discharge, and the remedy for that is under the compensation provisions of the Act, which provide for compensation for diminution in value. So it's a matter for the valuers to decide whether there is diminution in value in those circumstances.
Okay. Yes, my Lord, I think we probably keep our position open on that, but certainly I'm prepared to acknowledge that that is the conventional compulsory purchase measure, which does not normally allow for a consideration payment, only a compensation payment.
But it might be another reason why it was to the advantage of the undertaker negotiating for a contractual licence on payment of a rental.
Indeed.
Because then there's no question of compensation.
Yes, my Lord, yes.
But because the parties have agreed what monetary consideration is to be paid for the licence.
Lord, yes. It's like most consensual arrangements, it solves a whole host of problems.
So do you accept that once you've entered into a licence that displaces the statutory compensation? It's meant to be instead of?
Well, it must be instead of, yes.
Okay, thank you.
So now I think we've crept forward perhaps to the 2nd of January 1991.
I think we can get to the 29th of March 2022 in fairly short order, my lady. So, given all that, we do not accept the judge's characterisation of the agreements as licenses to pollute. We say that as somewhat pejorative and not accurate description, and we certainly prefer it the way Lord Justice Nugee just expressed it, that in effect everything was being consensually addressed. And there was a clear tit for tat. There was consideration given generally on both sides, without apportionment. Now, the highest way in which United Utilities' argument against these agreements is expressed appears to be that the one argument is that the entire agreements are void. If that is... Sorry, John?
I think we're putting it on the basis of the termination provisions. Rather
You're not saying the entire thing's void. You're not trying to get your rent back.
No, quite so. In fact, we'd be quite happy if it were amended to plead they were void, because then we'd be pleading prescription as well, because they'd have been void ab initio, but that's an aside.
That's not your case.
That's not our case. Our case goes simply to the termination provisions.
Very well. Then the United Utilities argument appears to be that a public authority cannot effectively bind itself not to exercise a statutory discretion if to do so would be to disable itself from fulfilling the primary purposes for which the discretion was created. Now, our answer to that is, first of all, to hark back to the words of Lord Justice Chadwick in the British Waterways Board case, at paragraph 48, I think it was, and to say that what was happening here was a discharge, a method of discharge by the local authority of its duty of effectual drainage. And to say that it was therefore disabling it by agreeing a terminable arrangement, to say that it was disabling itself from fulfilling the primary purpose for which the discretion was created is simply a motive overstatement. We rely particularly on the decision in the Starcliffe case, which is in the authorities bundle, tab 30, volume 2.1.
Mr. Morgan, I think we've already perhaps run over time, and I just wonder how much more you have to cover, and whether it's sensible to let you cover it now or to start again in the morning.
Probably 15 minutes, my lady. It's a matter for you.
On that basis, is everyone content to go ahead?
I'll deal with it as briefly as I can.
It seems to me that you should carry on.
Thank you. Yes, we rely on the case of Starcliffe Estates Company Ltd and the Corporation of Bournemouth, which is in tab 2.1 of the authorities bundle, beginning at page 161. Reading the head note, when a corporation purchases land by agreement for any of the purposes for which it is authorised to acquire land by the public health or other public acts or by special local acts, it is not ultra vires for the corporation to enter into covenants with the vendor restricting the erection of buildings upon the land purchased, which it might erect under other powers given to it for the benefit of the public, provided that such restrictions do not prevent the user of the land for the particular purposes for which it was required. And we have sidelined or one or the other of us has sidelined the passage beginning on page 166 of the bundle in the judgment of the Master of the Rolls, Lord Cousins Hardy. Foot of page 166, but the second point is this: is the covenant binding upon the corporation? I ask myself, why not? It's a voluntary bargain. There is no dedication by Parliament of this particular land to any particular purpose. The purposes are defined by the parties in the deed itself. Can it seriously be contended that the corporation cannot accept as a gift and make a purchase of land for a park, subject to any restrictions of any sort or kind, such as, give one which is very reasonable, very common one, that no intoxicating liquor shall be sold on part of it? Of course, if Mr. Grant's argument is about such a condition, it would be impossible. But further, if they've taken this conveyance of this land in terms subject to these restrictive covenants, can they hold it free from these restrictions? That again is a proposition that seems to me to be startling. If the deed is wholly ultra vires, I can understand it. But to suppose that the corporation could be allowed to retain the land and to repudiate a consideration or part of the consideration for it is a proposition to which certainly I could not give my adhesion. We say that it's the same here. That it's far-fetched to say that the arrangement was of no useful purpose when the licenses endured for many decades. And of course, they did not result. There was no power of immediate determination. There was determination on notice, agreed notice. Not of days, not of weeks, but of months, either 6 months or 12 months. In the course of which we submit it is perfectly reasonable to assume that other arrangements could be made, and in particular that the local authorities took the view that it was sufficient to enable them to be made. And it seems that Mr. Carris's argument would apply even if there was a very long period of notice, because you would still be getting a smaller measure than under the implied right. I'll just finally then address the respondent's notice, although I think much of the ground has already been covered. Indeed, I think really it's probably all been covered, and unless I can usefully assist the court further, those are my submissions.
Can I ask you this? If Section 116 does apply to these outfalls, what happens? You give notice terminating. Under the licenses, it's the contractual obligation of UU to take their pipes away. But Section 116 says they can't do that unless they provide another one. Is it your submission that that's just tough, they'll be in breach of contract or breach of statute?
Well, yeah, I can put it as bluntly as that, because of course they've had since 1989 to do whatever was necessary to avoid that state of affairs arising until notices were served, I think, from memory in the mid-2000s or whatever. So they've just, as it were, in the colloquial, sat on their thumbs, which ameliorates the sting of the point that your lordship is making. And Lord Sumption acknowledged in the Supreme Court in 2014 that the solution he had come up with went beyond the problem that it needed to solve, because it was giving perpetual rights. And I can take your lordship and your ladyship to it if need be. There's a passage in his judgment where he recognises that, you know, if it were possible as a matter of implication in English jurisprudence to say, as a European court would say, oh well, we'll give you 10 years to do it or whatever, then that would have been a more neat solution which would have matched the problem. Well, that's exactly what we have here, that
Yes, but in theory, at the end of 6 months, if it's a 6 months notice period, you
Yes.
give your notice in 2000
Yes.
something. At the end of 6 months, what do you say the position is?
Well, if I'm allowed to use hindsight, I know what the position is, because the agreements were terminated and the discharges continue.
So you say that they were not in breach of a statute because they didn't stop up, remove their pipe, but they were in breach of contract.
Yes.
And you're suing them for breach of contract or for trespass or what?
Yes,
Which is it breach of contract or is it trespass? Or is it both?
trespass.
The normal remedy for a tort that's a continuing tort is to get an injunction.
Yeah,
Can the court grant an injunction forcing them to act in breach of statute?
well, it is likely that the court would, in those circumstances, elect to award damages in lieu of an injunction. Of course, there's an enormous 19th century jurisprudence about the courts doing precisely that, where the local authorities discharging sewage were caught very short, as it were. And I think in the case of the litigation involving Lord Adderley's estate on the River Tame, downstream of Birmingham, I think one injunction was suspended for nearly 50 years. So the courts of equity have got plenty of flexible tools in their armoury to deal with such a situation. And in effect, what occurred there was that all enforcement, as it were, was put on hold while the city of Birmingham went about inventing modern methods of sewage disposal. And there's no reason why that state of affairs should not prevail. The common sense would prevail. And that would be reflected in the flexibility of the remedies.
Thank you.
Lord Justice Arnold? Thank you very much indeed, Mr. Morgan.
Thank you, lady.
And thank you for completing your submissions today. And so 10:30 in the morning, and we'll be on to Mr. Garris.
Yes, and I anticipate I should be the better part of the day.
All right.